the commission with a great deal of enthusiasm and dignity and industry, which is really wonderful. I've had the privilege of working with a number of people. As I said, James Hodge, who's now the chief economist, and it's a wonderful thing to see somebody who had come from private practice to be dedicated sufficiently to the cause of competition law and enforcement to have come and offered his very extensive skills to the commission. And equally to Simon Roberts, who preceded him. You know, it's all very well that from time to time we're critical of the testimony and the expert advice that economists give one way or the other to the appeal court. It's the nature of the game, but that doesn't mean that one doesn't have a very abiding respect, affection, and admiration for the work that is done. And in the case of James and Simon, that is certainly true. And speaking of admiration and reflection of the extraordinary contributions made, I have to say that I have been really privileged as the Competition Appeal Court Judge President to work with three extraordinary people at the Competition Tribunal. There are many of them, but I do want, if I may, to single out the chairs. David Lewis, who I know got very cross with me on numerous occasions when we overturned the tribunal's decisions, but no one, certainly not me, was not deeply in admiration for the construction of judgments that David did, for his extraordinary insight and ability, creativity, and leadership of the tribunal in its early stages. South Africa was truly lucky to have someone of that caliber, and I know he hasn't been well recently, and I hope he's really on the mend, because he does such wonderful work now in other areas, including Corruption Watch. To Norman Minoyam, similarly, the tribunal couldn't have asked for a calmer, more steady hand to take over from David and continue the good work that was done. I know Norman is now acting as a judge, and they're lucky to have him there. And I really, again, want to record my admiration for the decisions that he has piloted through the tribunal. I know the busy load they have. It is quite incredible. And the fact that these judgments come out from the tribunal of the intellectual quality they do redounds to his and other credits of others. And again, the same applies to Mondo Mazwai, who's now taken over and who, as we see as cases come up to us, has maintained the same careful and rigorous standards as her predecessors, and I have no doubt is going to lead the tribunal with great distinction. And it's an enormous pleasure that I've also been able to work with her. I should also record, of course, there are many, but Yasmin Karim, who's been there for so long, Yasmin, who too has been a real pillar of strength, and I wanted to record my appreciation to her. Tembi has spoken about the Competition Appeal Court judges. I will speak to them separately, but of course I've had incredible joy of being able to speak with many, to work with many of them, watch many, I might say, pass through the ranks of the Competition Appeal Court to the Constitutional Court, to the Supreme Court of Appeal. I've almost felt quite often like Captain Scott alone in the tent whilst others have left. But the truth about it is always a joy for somebody who's sought to appoint people to one's court to see them blossom and move to higher courts and function with such distinction in higher courts. So much, therefore, for thanks. Let me talk then a little bit about the reflections. It seems to me that when we started in 1998, you have a real problem as a lawyer. If you think about it, we lawyers generally have to go backwards in order to work forwards, by which I mean this. Lawyers, not particularly original, certainly judges aren't. The point is that you rely on precedent and what has come before you in order, as it were, to craft decisions for the future. And when you think about it, when the Act was passed in 1998, there was no precedent. yes, it is true that we had precedent from other countries, but how then to incorporate that precedent into South African jurisprudence, which clearly, luminously, and eloquently reflected the indigenous conditions of South Africa in the preamble to the Act and Section 2 thereof, the Objects Clause. Both of these were very, very specific to South Africa. And consistently over time, one found oneself having to remind counsel that automatic, as it were, almost Pavlov-type borrowings from antitrust cases in the United States of America, abstracted from the South African conditions and objects of the Act, were not necessarily appropriate. And certainly the tribunal, as I've indicated, I think early on, did a magnificent job in this regard. And when I think about it now, we were lucky because David, Norman, and I all were holed up. I so remember in that wonderfully salubrious place called the King's Cross Holiday Inn Hotel, which is where I first met Eleanor Fox, who did such towering advice work for us and shepherded us under the broad leadership of Alistair Reiters, the very fine Director General of Trade and Industry at the time, to get us an act. And those sessions in which certainly I made a very small contribution, but I learned so much from Eleanor, who has continued, as it were, to assist us, as have others, and I'll come back to them in a moment. But how to craft a jurisprudence for a South African Competition Act was, I think, the great challenge at the time. And I think when I look back at that first period, there were missed opportunities. And there was certainly a missed opportunity to develop the kind of coherent normative framework to which Thembi has made reference, and which would ultimately have guided both the tribunal and the court in its further deliberations. And so, yes, it is true. I do look back at the nationwide Pales case, where Mr. Foote, a small producer of creosote for poles, which were required for agriculture and other fences, took on the might of Sasol and a massive team led by David Unterholter SC, now Mr. Justice Unterholter, won before the tribunal, but failed at the hurdle of the Competition Appeal Court. And it's a judgment which I've taught many times in many of my teachings at various parts of the world, LLM and LLB and other courses. And it's a judgment that has troubled me greatly, because it does seem to me that here was an opportunity, particularly with a small producer, to firm, to craft something more substantive with regard to a normative framework, one which would have embraced the ambitions encapsulated in the preamble and Section 2 of the Act. The defense, of course, is that it's very difficult often for judges to do that when they don't get the level of assistance from counsel. And of course, Mr. Foote was acting for himself. And you may remember that the Competition Commission was not in that case. It's got nothing to do with you, Thembi, but it was, because it was long before your time. But it does seem to me to have been a moment of regret that they were not there, for I feel sure that if they were, we may well have come to a different decision. And I do think, therefore, that, and I want to come back to this, that we only partially got to the embrace of something beyond the standard consumer welfare standard, which itself is problematic. The other case which comes to mind in this regard is Mittal. Now, with the Mittal case, which, of course, if you may remember, was to deal with excessive pricing, there again the commission was absent, and the case had been brought by Harmony. And effectively, what we had done was to create a reverse onus, which would have certainly an evidential onus, which would have meant that Mittal would have had to go back, because we wanted it sent back to the tribunal for further determination, in that we didn't think that David Lewis's idea of super dominant firm itself, and therefore no cognizable competition explanation for the prices were on its own sufficient to sustain that which the text had indicated. More about that in a second. But it did mean that we had sent it back to the tribunal on the basis that Mittal was going to, at least on the evidence, have to show how it was that their price was reasonable. It's exactly that particular dictum which now finds its way into the amended Section 8, and rightly so. And so the problem of that case was that had I known that Harmony were going to, as it were, pull out, and it's true that David Untal's SC warned us about this at the time, saying that his client didn't have endless pockets, but be that as it may, the problem of that case was I think it would have given us a better opportunity to do something which I also regret upon reflection, which is the integration of the analysis to firms which had previously benefited from massive state largesse, as in the case of Mittal. It is true that that was also the case in Sasol, but as I explained at the time to the commission, and I was very happy to do so at the time, to explain that I thought it was the evidential problem there, that had there been an adequate analysis of the return on capital that Sasol had extracted, the result would perhaps have been very different. And there I think it was an evidential question. It may be argued that in that particular case, again, we lost the opportunity of interrogating the largesse of the large state-owned enterprises that now have been privatized. But the opportunity really was in Mittal. And had I known that the case would never go back to the tribunal, I might well have decided differently, which is why when it came to Walmart, we were not going to take a chance and send it back to the tribunal to interrogate questions of the fund, which we ordered as part of the conditions for the merger, but did it ourselves, precisely because I didn't want that opportunity to go begging at that time. But these are cases, upon reflection, and it does seem to me totally appropriate for judges to actually reflect on where they might have gone wrong. We are not infallible, even if some of us think we are, and we need to reflect on mistakes so that we don't perpetuate them as we go forward. So it does seem to me, therefore, that we have to, having got through that first phase, we have to at least have the following reflection. How far have we shown fidelity to the objectives of the Competition Act? How far have we extended the jurisprudence to develop a normative framework which is different to that of other countries which don't have the textual supports for the normative framework that we have? And I do think that we have not succeeded to the extent that we should. I'm going to come back to reasons for that in a moment, if I may. But let me say this immediately, that a failure to democratize the economy, a failure in a sense to ensure that the blockages to allow for a competitive process to benefit 60 million South Africans and not just a few, is certainly something one has to take very seriously. And I have little doubt that that was part of the object of the 2019 amendments. And I find it regrettable for myself that other than now sitting on writing the judgment in the Babalegi excessive pricing case, which obviously I'm not able to talk about at this point because we haven't delivered judgment, I'm not going to be able to participate in some of the further extensions. But I do think that the issue of what we now take as being the guiding set of principles to ensure that we develop a coherent jurisprudence post the 2019 amendments should be our greatest challenge. And talking about which, we are not the only country that is facing this problem now. I do think that competition law, and this comes to the second phase, competition law is at an inflection point. It might well have come to an inflection point notwithstanding COVID-19, in other words, without COVID-19, but unquestionably, we are now going to have to make some very tough decisions about how our economy is going to respond to increasing levels of concentration, increasing levels of inequality, and the fact that economies the world over are not delivering to the citizenry. And to that extent, at least in part, we have to say that these failures have given rise to the sort of populists who seem to dominate the political terrain right across the world. And we ourselves should not be particularly oblivious to the problems that might well occur in South Africa if we aren't able to deliver to that extent. And so I do think that the question which is going to challenge us going forward is precisely how do we see competition law in the 21st century in the light of where we are. In South Africa, we have some textual support for that, but the truth about it is that we need to do much more. And I think there's been a failure of competition law in many parts of the world. We have ceded competition law to too many conservative economists who demanded complex economic proof and who seek, as it were, to try to avoid false positives whilst at the same time essentially ensuring under-deterrence. And so we've also, it seems to me, competition law around the world has ignored the adverse political consequences of the return to a kind of conservative set of economic principles which came in with the Chicago School and which have not left us. And that is true the world over. And let me come back to the challenges of South Africa in a moment. But I do think all of that is particularly important. And that does mean that we are going to require the assistance of both economists and competition lawyers to look to what it is that animates competition law going forward. It seems to me there was never a rigid consumer welfare standard in South Africa, but the new act now does require considerable new thinking. And we shouldn't be nibbling at the edges. We should be grappling with that in a broader sense. In other words, how can competition law contribute to deal with the problem of those disadvantaged by inadequate competition outcomes? To what extent do we have to take the principle of the realists such as Robert Hale back in the 1930s to realize that markets are constructed by law? The point made very, very luminously by Katerina Pasteur in a new book, The Code of Capital, which shows that particularly, and therefore we can't duck the consequences of how certain rules shape distributional consequences, let alone allocation. And it does seem to me that we need, that is the challenge in the post-COVID world. It also seems to me that we may, and I think South Africa definitely, in terms of its competition jurisprudence, has to advance concepts of social justice. Social justice through thinking through a market mechanism and the processes of a market which do promote social justice, which means looking more carefully at the impact on small and medium-sized business and consumers and participation in the economy as a whole. And that doesn't necessarily mean that we have to invent new concepts. Let me give you one illustration. And it's probably because I was so influenced as a student by Renner, who wrote the wonderful book on private law and who argued that, in fact, concepts don't change, the content of concepts change because of different economic conditions. Take the concept of the essential facility doctrine. It does seem to me, not just with vaccines, but also with the entire digital debates, that the idea of the essential facility doctrine, which has always been on the back burner, may well provide a kind of concept which you're going to have to give new content to in order to open up the economy in a manner which allows for the competitive process to be developed in a far more fundamental way than otherwise would be the case. And so the point I'm making is that when I reflect upon our 20-odd years, 22 years of our jurisprudence, I think we did okay, but not more than okay, in moving ourselves in the direction of what the object was. And I do think that even though that I differed with David Lewis and those early judgments. They do bear reading, because to some considerable extent, they did seek to do precisely what I'm arguing. Question is, can we do them in a manner which, to a large degree, shows a fidelity to the text of the Act? And talking about text, that doesn't mean a literal idea. That doesn't mean the nonsense pursued within the United States of America of originalism when it suits judges. I'm talking about the fact that, on the other hand, texts do matter, and there are constraints upon what judges can do. But within that framework, there is much that can be done, precisely when you've got the pro-pointers, interpretive pro-pointers in that direction. So let me just make 2 or 3 final points. I would, of course, want to talk about the conceptual points to a greater extent, but time is not with me. So I want to just make a few additional remarks, if I may. It seems to me, when I look back on the period in which I have presided over the court, that you can blame judges and the tribunal when you don't like a decision. And it is true that, as I've tried to indicate, by virtue of the fact that I've reflected on a couple of our judgments, and there are others, where perhaps the result should have been different, perhaps with a different nuance to argument they would have been. But apart from that, there are 2 other constituencies that really are vitally important in the shaping of the jurisprudence of competition law: the economists and the lawyers. Let me talk about both. In relation to the economists, I've already indicated that I think worldwide, and particularly the United States of America, but not only, conservative economists who, in a sense, have adhered rather rigidly to a particular form of economic paradigm and have been particularly obsessed by false positives, and effectively have asked or demanded the kind of econometric proof, which I'm not entirely sure is always necessary, and as sure as goodness is not necessary if you broaden the intellectual imagination to take account of questions like fairness and social justice. And of course, without saying more, it is true that the cases dealing with excessive pricing, which Mondo has spoken about, have much more to do with distribution than they have to do with allocation. And therefore, I have not been convinced at all that we have been the beneficiaries, give or take exceptions, and there have been, no question. So let me say that immediately, that we have been the beneficiaries of the kind of economic evidence which would have allowed for a more transformative jurisprudence to be sustained on a more rigorous and consistent basis. And so there has to be some thinking within the economics profession, in particular, about how this is all to be done, and some reflection on why it has been that competition law has not been able to deliver on the goods. It may well be said, and it will be said by the conservative economists, well, that's not your job. But as I've tried to argue, I don't think in the 21st century post-COVID that argument is open any longer in the light of where we are. I do think that these border questions have to be taken into account. An original and narrow conception of efficiency alone just simply doesn't fly, certainly doesn't fly for our jurisprudence. It didn't fly when we started with the public interest jurisprudence, and yet it is now true that many countries think that the public interest, in which we were once upon a time an outlier, is now something which is somewhat more necessary than certainly was argued to be the case when we introduced it. There is a second aspect, and the second aspect is the aspect of the lawyers. And I've said this often. I do not think you can simply argue a competition case one day and a running down case the next day and a medical negligence case on the third day. I do think it requires some level of specialization. I know that we're not going to have just a situation of a whole host of competition lawyers who do nothing else. But Tembi, for example, mentioned the banking case. And it was really distressing for me to hear many senior counsel who are distinguished in various fields get up and argue in circumstances whereby I really would want to say, with no disrespect, that my students in competition law would have known that there was a jurisprudence that they had to address, which they hadn't. It just seems to me that one cannot go on this basis of law firms briefing people who really don't know the field. And talking about law firms, it also seems to me, and I've said this often, and it's something that I failed, I regret it, that we have not seen the transformation of representation in the profession with regard to both race and gender to the extent that we should. And that is particularly galling to me in the sense that I know that competition law, not that any other law falls in, can be categorized differently. But let me just say this, competition law is unquestionably not the repository simply of white men. Does that mean that I'm suggesting that white men should be excluded? Not at all. But what I am suggesting is that when you come before, as we did in the banking case, a bench in which there are 2 black women and 1 white man as the bench, and other than the commission's lawyers, we're dealing almost exclusively with white men. You have to ask yourself, why is that? What about those black lawyers and women who, in a sense, have come before us consistently over time to their great credit? What is it about law firms that there's a glass ceiling here? And why is it that some law firms who practice competition law almost exclusively, and they know they are, only will brief certain white men and no more? It's just not on. And it seems to me that that creates broader problems for those of us who want to ensure a seamless movement from the profession to the bench, in which a transformative bench, in a sense, is powered through lawyers who've been given the opportunity to practice in this area. And so I do think I failed on this. I know Tim Beckett and Gotoibi said this last year at the conference that my experiment has failed, and I acknowledge that. But that doesn't mean we shouldn't continue to try. I also think, to a large extent, that when matters do essentially move out of the specific field, specialist field, from the competition tribunal, competition appeal court, to the constitutional court, it does worry me that a constitutional court that gets the occasional case, particularly when they're complex cases like predatory pricing, deal with these, quite honestly. I'm perfectly happy that if they deal with them on the basis that there are constitutional problems or similar problems, that is indeed where they have real expertise. But I think consideration is going to have to be given to having some people, at least on the constitutional court, who can deal with these matters with a level of kind of expertise that is required. Otherwise, there's really very little point in having specialist jurisprudence in the first place. And maybe that means that the constitutional court will have to do what we do, which is to actually have specified sessions. Tembi has made mention of this. You know, over time, we've had Eleanor Fox, Stephen Salop, Harry First, and others who've come along and given us bespoke. Richard Wish is a further in the early days of our jurisprudence, where they've come along and they've actually been incredibly helpful in being able to educate many of the judges who've not had the benefit of much competition experience. And I do think that's important because we want to develop a coherent and plausible jurisprudence going forward. So in conclusion, let me say that I'm delighted to see the program for this particular conference seeks to deal with some of these questions. I hope they're embraced. I hope that they percolate through the portals of both the legal and the accountancy, and economics professions. I'd also want to say this, competition law is really important. It's important not because it's the only mechanism, it isn't. I think Norman Minoyem did make that point in Walmart. It's not the role of competition law to save the world, but it is the role of competition law to ensure that the economy works both efficiently, justly, and fairly, that the competitive process works for 60 million people, that it doesn't just work for the advantaged, but also for the disadvantaged, who not only historically disadvantaged, but remain, sadly, presently disadvantaged. It does seem to me that that is the task going forward. It seems that if South Africa is to move out of the really difficult circumstances that it finds itself in, as do other countries as a result of COVID-19, that we're going to have to rethink so much about what the narrative of our economy looks like, to borrow from Robert Schiller's most excellent book in that regard, Narrative Economics. But what we're also going to have to do is to have the commitment to ensuring that it is an economy that works for all in this country, and does so in a way where blockages, which are basically inherited from our apartheid past and from the privileges given to few as a result of that past, are in fact finally and inexorably removed. And that is the challenge. And when I look at people in the Competition Commission and the Competition Tribunal and those of my colleagues in the Competition Appeal Court, I feel confident that that will happen. And I wish you well. And because your work is going to a large degree, ensure the future of the economy in South Africa. It was Roosevelt who said, the only thing we have to fear is fear itself. And it seems to me in the rather difficult circumstances that we find ourselves, we need to realize that, to lift our gaze, to embrace the objectives of the Act fulsomely, to ensure that we do not just perpetuate the economic and legal shibboleths of the past and move forward in a manner in which this Act actually does work to ensure that the markets work for everybody. Thank you very much.
Thank you very much indeed, the outgoing Judge President of the Competition Appeals Court. Just out of interest's sake, I don't know what it is that is your plan for 2021, but I'm sure you will get communication either from Mr. Thembinkosi Bonagele or the Director of the Competition and Regulation Project from the University of Fort Hare. In 2021, they're starting an LLM program on competition law, so that's certainly something for you to do. But more to the point, in tackling questions on transformation, I do pity the fact that we only have 194 participants, because so poignant to some of the issues that you have raised on transformation and the supposed ceilings that exists within the profession. I see a couple of my ex-employers. I'm glad they had an opportunity to hear that. It is a pity your words have not resonated to a wider audience, where especially it is desirable that your thoughts be heard. Judge Davies, thank you then so much for your years of service and contribution to the making of the South Africa that for the most part we can be proud of. That's not at all to suggest that there isn't work to be done, and you've elucidated pretty well where exactly some of those interventions are necessary in the course of the next 2 decades of competition law and policy regulation.
Can I just abuse my last minute by saying I forgot to say that, Sangeze, and I am more than happy to speak to the Competition Commission, anybody else who wishes. I certainly do not intend to shut up. I really do hope that I can continue to assist in any way I can.
Not that I would ever succeed in getting you to shut up, but it probably was never going to.
But thank you very much.
Thank you so much for confirming that. Well, we will use you accordingly. Colleagues, all 192 of you plus me, 193, thank you so much for joining in what has been quite a special first segment, changing of the guard in the true sense taking place. We look forward to the judgments that will come through from your desk, JP. It is now time for tea. It's time for us to all refresh. We will be back, please, because we are on time. And thank you so much for the indulgence you gave us there, Ms. Mazwai, because that 10 minutes you did not take has allowed, well, at the back end of this particular segment, a critical 10 minutes, and it's quite difficult now that we have what we have to stray from it. 11:30, we do come back with the parallel academic session 1. 11:30 until 12:30, my colleague, Ms. Nandi Mukwena, will be leading you in that because I have to participate in some of these sessions. So colleagues, it's 10:47 now. We have just over or just under 45 minutes to take a tea break. And as soon as we are ready at 11:30, strictly because everything is ready now, we will get on with the balance of day one, Tuesday, 3 November. It is the competition in a crisis, competition policy, regulation, and enforcement in unprecedented times.
Orange Under Fire, which I'm sure some of your audience have seen. But the gist of the story was he was a tank
Hello.
Hi, Sumaya.
Yes. Yes.
How are you?
I'm good, thank you. How are you?
I'm fine. Are you on the first academic session?
I am. Sorry, have I used the correct link?
You're on the panelist link, so.
Okay, great. Great, that's
yeah.
great.
I see Tanya is also with us, and she is
Yes,
your.
I've also joined.
Assistant.
So, hi.
Tanya, I can see that
How are you, Tanya?
Tanya, I see your four. Okay.
Is that better?
That's perfect.
I just
Yes.
can't see myself on your screen. So, and I'm working on my laptop and another, so it was down.
Everyone.
Yes,
So
Jason?
listen, everyone, we need to turn off cameras and microphones because this has been broadcast live. We can just converse on the chat function.
Sure.
Thank you to everybody for joining us. It's just after 11:30 and we're going to begin with our academic sessions. So welcome back again, everyone. We're turning to the academic sessions now of the conference. There are 2 of them today. The first one runs from 11:30 to 12:30, and it's titled Competition Policy and Enforcement and the Economic Recovery for the COVID-19 crisis. So it's really appropriate for this time that we're in right now. The session has contributors who have submitted papers of a really high quality on this topic. Our moderator and discussant for this first academic session is Tanya van Mellis. I hope I said that right, Tanya. Tanya van Mellis is the Chief Director responsible for competition policy in the competition branch of the Department of Trade and Industry and Competition. She's going to introduce the panelists and the papers under discussion. Now, if you would like to ask questions as part of this panel discussion, please write them down in the chat section on this platform. We're going to go through them, we'll group them, and we'll post them to the relevant panelists. Tanya, can I please hand over to you?
Right, hi. Right, good morning, everyone. Thank you very much for joining us and for what I'm sure will be a very exciting first session. The session is Competition Policy and Enforcement and the Economic Recovery from the COVID-19 crisis. We're very lucky to have 3 very knowledgeable and eminent presenters. So firstly, we've got Phil Alvers, who's an Associate Director at the Berkeley Research Group. Then we're going to have Sumaya Goga, who's a Senior Researcher at the Center for Competition, Regulation and Economic Development. And lastly, we'll have Dr. Thando Vilakazi, who's the Executive Director for the Center for Competition, Regulation and Economic Development. If you want to see any of their bios will be pasted in the chat area. And can I just reiterate what Nandi had requested you to do? As we're going through, if you've got any questions you want to ask, please just post them in the Q&A area at the bottom of the Zoom screen. So without further ado, I'm going to hand over to Phil. Phil, you've got 10 minutes to present.
No, the paper is being presented on session of the...
Hi everyone, can you hear me?
Yep.
Okay, great. Very happy to be here. Thank you very much for those kind words, Tanya. And thanks to Jason and the Commission for indulging our delays and the length of time we took to get this paper in, but we got there in the end. 10 minutes isn't much, so I'm just going to dive straight in. What did we do? Well, we wrote a policy in a long time, but it was a great exercise for me. I learned a lot. And I'm looking forward to this this discussion on this panel as well, where I should learn a lot more. What did we try and do? Well, we tried to answer the question, what role should competition law and policy, as 2 distinct things, in my mind anyway, be trying to play in South Africa's recovery from the economic impacts of COVID-19. To do that, we first looked at what were the sort of big pressing debates in the world of competition policy and antitrust in the West, before COVID-19 hit, because that's the right context. Then we looked at how the impacts of COVID-19 and sort of suggested, or discussions around suggested or optimal responses to it from the competition world. You know, how have those impacts changed, if at all, those pre-existing concerns, which obviously haven't gone away, they're still there. And the paper spent quite a fair bit of time looking at what South Africa had been doing before COVID-19 hit. But the sort of meat and potatoes is really about what South Africa has done since COVID-19 hit, again, from the competition policy angle and competition law angle, and what South Africa could be, you know, considering. And there, I think the end of the paper does need some refinement. We basically tried to split it up into sort of short-term options and longer-term options, and we saw short-term options as being almost exclusively in the beyond the law field. So competition policy, what can it do alongside industrial policy? And I think that needs a bit of a refinement. I'll explain what I mean later when we get to that part. So diving straight in, the main concern, I think, as we all know, before COVID-19 hit, I mean, lots of people were writing about it. And it's a concern, I suppose, that I've only read about in the context of Western economies, Europe and North America, but certainly also applied in South Africa and was discussed a great deal in South Africa. What was the concern? Well, rising concentration and the impacts of rising concentration on, competition, but also, the performance of economies, growth, and then, social concerns like inequality, and even, discussions, particularly in the context of digital markets and digital platforms and their regulation, threats to the functioning of democracy. There was a great speech, in my opinion, a great speech done by the head of the CMA at that time, Andrew Tyree, in 2019, setting this all out. And he referenced sort of surveys in the UK where people are increasingly, less confident in the ability of competition and market competition to deliver outcomes that are desirable for society. And he linked it to a broader crumbling of what he called the post-Cold War consensus. Well, what he sees or argues is a crumbling of that post-Cold War consensus, and that at the risk of gross oversimplification, I don't know what happened there. Can you still hear me? My window just closed. I think I'm back.
No,
You're
I
back.
can hear you. Keep going. Go.
So in a nutshell, that consensus was in Tyree's view, the need to promote competition via, trade liberalization, import competition, globalization, via the enforcement of competition law, via ex-ante regulation targeted at competition objectives and related measures. And he sees fairly good evidence for that consensus crumbling, and therefore, he called in 2019 in the context of the UK at least, for a fundamental rethink of not just competition policy but law, and he called for fundamental legislative reform. The paper then, reflects on some of these things in the context of South Africa. I won't go into it here because I don't have time. But obviously, as we all know, South Africa is ahead of the curve internationally on these things, having amended its law largely in response to concerns of a rising concentration and the impacts thereof on things like inequality. But what I will say is, in our review of what's sort of been happening in South Africa, what was happening in South Africa before COVID-19, it does seem to us that, government policy in general still sees a very important role for competition, or the promotion of competition, as a big important lever for promoting growth and promoting prosperity. I mean, it's in the Commission's Competition Commission's kind of tagline, promotion of inclusive growth. So we do see that as a sort of fundamental starting point. There's no rethink as a result of COVID impacts that the promotion of competition should somehow the prioritization of that should somehow be changed. But what the paper does say is that we're a little bit unsighted on whether or to what extent the COVID recovery and reconstruction plan and the industrial policy master plans that are a big part of that reconstruction and recovery plan. We're a little bit unsighted on the extent to which those plans see a big role for the promotion of competition. And there's the very obvious related question, which is if they do, in what ways? Is it the way that we've been trying to promote competition until now, or is it via other means? So that brings us to some of the debates that we've read about or seen overseas, again in the context of Western economies, largely European, about well, what new questions are the impacts of COVID throwing up? And the paper comes up with, well, the paper identified 3. There's probably more, but we got to grips with 3 of them in the time we had available. Again, I'm talking about Andrew Tyree. he came out with an interesting paper a few months ago saying, essentially the biggest risk posed by COVID is an exacerbation of the biggest concern we had before COVID, which is rising concentration. I mean, he sees a decline in international trade and import competition as one major source of reduced competition. He sees the likelihood of larger firms surviving an economic downturn and smaller, more dynamic competitors having to exit as another source of rising concentration and insulation of those firms from competitive pressures. He sees risks in bailout programs, in what he calls inefficient bailout programs. And worries that these will essentially keep alive firms that maybe should not be kept alive. And so overall, he's arguing essentially for a doubling down on sort of strict and vigorous competition law enforcement, and also, competition authorities nosing their way in to other parts of government policy or functions, sticking their nose in those functions as the COVID recovery process unfolds. And in particular, he's talking about bailout programs and what the CMA can do there. He does also note, of course, that this is all happening in the context of a sort of prior concern, which was that the whole competition policy and law framework needed a major overhaul. And so he notes that this whole thing is very, very complicated. Frederick Jenny is the second view that we identified. He's head of the OECD Secretariat Competition Committee. And effectively, what he was saying is, well, actually, when economies fall well below full employment, as they have as a result of the COVID-19 impact, economic impacts of COVID-19, you do need to actually step back from traditional competition law enforcement, which essentially focuses on short-run static impacts and less on sort of longer-run dynamic processes. He argues that the sort of traditional approach to competition law enforcement and the overall prioritization of the promotion of competition via traditional competition law enforcement may not be that helpful in current circumstances. And that, that was sort of an eye-opener for me, given that South Africa is, almost permanently well below full employment. And then the third view that we identified comes from Jorge Padilla and Nicolas Petit, two leading thinkers in Europe. They basically spoke about merger policy or merger enforcement policy. And they said, look, we need to be very, very smart about this, and we need to be very, very careful about state aid and bailouts, keeping what they call zombie firms in keeping them going. They see an opportunity for the economy to essentially be cleansed of zombie firms through very intelligent and sort of purposeful merger enforcement coupled with state aid or bailout programs. And again, suggesting a change to merger enforcement. So turning to South Africa, because I think I've only got about 2 minutes left. So as I said at the beginning, our paper kind of took the view that, well, we've changed the law. The Commission's adopted a pretty new and innovative approach to using the tools available to it. And so we don't see a lot of potential for further changes in the law or changes in enforcement policy to have short-run impacts. But I think actually we need to revise that. And I think it's in the merger context. I think what Tyree and Padilla and Petit are saying is that merger enforcement needs to be pretty agile, pretty nimble, and pretty smart, because it can contribute to recovery by facilitating reallocation of productive resources away from firms that may be inefficient and towards firms that may be less efficient, more efficient. The Commission has said that it will apply the failing firm test vigorously in the context of sort of COVID mergers or post-COVID mergers. But I think there's a conversation that can be had around the sort of broader role for merger policy. Beyond that, the paper basically says, look, beyond that, it's really down to what competition policy can do in the short run to aid the COVID recovery, as opposed to competition law enforcement. And there we see essentially, I guess, two buckets or two categories of things that competition authorities and competition policymakers can think about. One is defensive, and this is going to the Andrew Tyree concern. Well, we called it defensive in our paper. And that's making sure that, industrial policy processes and programs and other, bailout programs and other initiatives to aid recovery we really do need to have people in the room there with the competition hats on to make sure that we're not scoring own goals. We're not inadvertently increasing concentration more than it would have otherwise absent those programs. And if we are going to take decisions that do increase concentration, can we make sure that we really understand very well the trade-offs that are at stake and the decisions we're making there. So that's what we call the defensive role. We also noted what we think are a few basic ideas that could be looked at in the short run, and that's things like using ex-ante regulation more aggressively to try and promote entry and competition and effective rivalry, using licensing regimes and development financing and funding of entrants. I've been asked to wrap up, which I will do. And then the paper ends with a discussion of, I guess it's actually a more longer-term project, and that is really about, whether or not South Africa should strongly consider embedding competition law enforcement in a much broader program of competition or the promotion of competition, which would entail perhaps a shift over time away from competition being largely or only about enforcing competition law according to the traditional approach, or even under the new laws, whatever approach emerges there. And it basically proposes considering ways of balancing the promotion of competition according to that approach with the sort of protection of longer run dynamics and incentives to achieve what some in the literature have called, optimal competition, rather than what you could say we have been doing in South Africa for 20 years, which is the pursuit of maximum competition. There is so much to talk about on that debate, and our paper doesn't do it justice. It doesn't do many questions justice. It's basically trying to introduce some of these debates and get a discussion going. And I think one of the other papers on this panel will do much better on the optimal competition debate. But that's the main contribution of our paper. We basically see, I think, a bigger role in the short run for policy as opposed to competition law enforcement, with the proviso perhaps of merger control. And I think I'll leave it there because I'm out of time. Thank you very much.
Thanks, Phil. That was really interesting. You covered a huge amount in a very short time, and I hope that people who want additional information will be asking questions and sending questions through. So you'd spoken about we needing to make a link to optimal competition, and the person who's written extensively on this is going to speak now. So Samaya, I'm going to hand over to you, and you've got 10 minutes.
Great, thank you, Tanya. My name is Samaya. So I will be presenting the paper, and let me just try and share my screen. Is my screen shared? Sorry, can I just ask if my screen is shared?
Yes, Tanya, we see it. Thank you.
We can see it. Thanks very much. Do you want to just turn it on to slideshow? Then it'll just make it a bit bigger for us.
Sure, that's great. Okay, so this is a paper on competition, productive capabilities, and structural transformation in South Africa. It is written by myself, Pamela Mondliwa, and Simon Roberts. And Pam, I see you're on the panel list as well, so please jump in if you feel you need to. And as Phil said, this paper actually is talking about this idea about optimal competition, why the need for optimal competition, and what we actually mean when we're talking about optimal competition. Also, essentially what the paper is arguing is that for capability development and structural transformation to occur in South Africa, we need a different approach to competition. And we're saying that the approach to competition needs to be different because the experience and the outcomes in the South African context show that openness, which is liberalization, together with competition law, does not substitute for a coordinated industrial policy that focuses on production. In other words, the kind of market-orientated policies that we have been pursuing have not led to a structural transformation of the economy, and that there is a kind of missing link to production. So the focus has not been on production. And at the heart of this problem, we argue, is the orientation of large firms and how they govern the value chain. So where large firms have been able to extract profits at the expense of smaller firms, they undermine transformation. And we see this in the case of our paper, and I won't go through these case studies, but we see this in the case of our paper through the metals, machinery, and equipment value chain and the plastics value chain, looking at the role of ArcelorMittal South Africa and the role of Sasol in terms of their pricing and in terms of how they have governed those value chains to the detriment of smaller downstream firms and to the detriment of structural transformation in those value chains. So what South Africa has actually done is that it has prioritized the use of competition law to discipline large firms. And this has not been effective, and we argue on two levels. So for instance, where firms have used excessive pricing, the competition law has not taken historical state support into account when determining if they have used excessive pricing or not. And so the cost competitiveness of downstream industries has actually been undermined. On the second level, as far as cartel conduct is concerned, although this has been successful through competition law, penalizing cartel conduct does not create competitors in the sense that insider firms can look at other ways to ordinate and extract rents, and this is difficult to detect. So as far as the use of competition law is concerned in governing value chains and in dealing with large firms, it has been somewhat ineffective as far as structural transformation is concerned. So we are arguing that we need to engage with power along the value chains and the orientation of these large firms. In other words, how do we grapple with these large companies and how they govern value chains? And the paper is arguing that instead of relying on competition law, we should rely on a range of tools. And these tools are industrial policy tools, they are the regulatory tools, etc. So industrial policy incentives, development finance, regulation of mining rights. In essence, because in South Africa we have separated competition law and industrial policy, government has tended to ignore these tools and has tended to focus on the competition law in order to deal with these large firms. So we argue that there is a need to move away from a reliance on competition law towards a production-centered or optimal competition approach. So what we're saying here is that instead of relying on competition law, we should say, what is the kind of optimal competition that is required in order to build capabilities, in order to build competitive assets, in order to get firms to invest in technology, etc. So the competition should be optimal rather than competition for its own sake. And here we're talking about a right kind of rivalry. So the kind of competition which spurs firms to innovate and invest. What we're essentially saying is that we don't want to put the competition cart before the capabilities horse. If we want to structurally transform the South African economy, what we need to do is we need to think about capability building. And if we want to think about capability building, the place we don't stop at is at competition law. The place we go to is what are the different kinds of tools that can build these capabilities and how does competition work within those tools. So in other words, how can competition and industrial policy tools work together in order to build capabilities and transform the economy? So how do we build and strengthen linkages in the production system, and how do we facilitate progress towards higher productivity activities? So then we talk a little bit more about what we mean by optimal competition. So we know that South Africa and other developing countries have pursued a kind of market fundamentalist approach. And this approach relegates government to addressing market failures rather than, and what we argue is that we need to kind of think about an alternative conception of government's role. And this is, how can government spur development of dynamic comparative advantage? How can it help to construct competitive assets? And therefore, how can it pursue competition that is optimal? So there needs to be sufficient rivalry, competitive rivalry, to reduce inefficiency within large companies and discipline exercise of market power, while also spurring investment and innovation. So the combination of competition and cooperation is really dependent on the stage of industrial development, the configuration of industries. In other words, in this value chain, how are the different industries placed within the context of the global market, then the context of the economy and the role of the state. And the examples of where countries have kind of used this kind of approach is in South Korea and Japan. So South Korea and Japan both allowed for restriction of competition during high growth phases in order to build capabilities. So that they could become internationally competitive. So industrial policy goals in these countries were pursued through appropriate competition policy for the time, noting, however, that there were reciprocal control mechanisms over rents. In other words, although they might have, although they did restrict competition for a time, they make sure that there were control mechanisms related to that restriction of competition. So in the South African context, what we're saying is that we need to pursue industrial policy goals using appropriate competition policy for the stage of development. And importantly, there needs to be a focus on production rather than exchange. In other words, how do we put production at the center of this debate and at the center of policy, so that competition policy and industrial policy work towards production goals rather than simply thinking about exchange. And so consider competitive, in terms of considering competitive rivalry across value chains, we're saying that in South Africa, for example, when we looked at the steel value chain and we looked at the Sasol to plastics value chain, the governance along the value chain is quite important. So not just horizontally, in other words, steel firms with steel firms, but what impact steel firms have on downstream industries, on foundries, on machinery and equipment industries, etc. So how do competition issues at the upstream of the value chain impact on downstream outcomes? And so what we're arguing is that we need to bring production back into competition policy for transformation. What does this mean in practice? In practice, it means that we need a kind of different approach to large firms rather than relying on competition law and international competition to address the market power of dominant firms. We know that competition law is litigious and the results have not always been great, for instance, in terms of the excessive pricing for ArcelorMittal South Africa, as well as for Sasol, and the results have not been great, particularly as far as input prices for downstream firms are concerned, and therefore for what structural transformation within those value chains actually means. So the different approach that we can take to these large firms includes enforcing and monitoring conditionalities on state support. So in instances where state support is given, it is really important to ensure that there are conditions related to that support, and that we monitor those conditions and actually enforce them. So for instance, in the case of ArcelorMittal South Africa, when it was internationalized, the developmental steel price for downstream firms was not concluded, but this should really have been concluded in order to ensure that the rents that ArcelorMittal actually inherited via ISCO were passed on to downstream consumers. The rents related to the low prices of iron ore. This was not done, and in fact, AMSA priced at import parity, and these input prices really did impact on downstream firms. Enforcing and monitoring conditionalities is really important, but we're also saying that we need to use a range of tools. In other words, competition law is one tool, but there's a whole lot of kind of other tools that are industrial policy tools that could be used in order to help to build capabilities and in order to structurally transform. And these include, for instance, regulation related to mineral rights, industrial policies, trade tools, etc. We're also saying that competition and cooperation must be balanced to support coordinated investments. In other words, whether we want a more competitive environment or whether we want a more coordinated environment must be balanced in order to support investments within that particular value chain. So in that value chain, what is required in terms of competition or coordination to incentivize large firms in the right direction in order to make them invest, and also in order for them to ensure that they pass their rents on to downstream firms as well. And finally, you're saying that competition policy must open up markets and enable firms to be local and international competitors in this. And this speaks to a kind of broader competition policy. In other words, what is the role of development finance? What is the role of technology policy? How do we create clusters, etc.? All with the purpose of focusing on production and focusing on production for the purpose of structural transformation in South Africa. So in conclusion, what we're saying is that competition is a dynamic process, and it can generate positive outcomes with the right rules and industrial policy support to ensure investment, participation, and broad capabilities. Thank you.
Right. Thanks very much for a fascinating presentation. You've given us lots to think about. The last person to speak is going to be Thando, who's also got a sector-specific example that he analyzes, and he's able to then draw larger implications from that. So Thando, if I can hand over to you.
Awesome. Thank you, Tanya. I was just waiting to be able to share my presentation. Cool. I think that should be coming through. Right. Thanks everyone. And thanks Phil and Sumaya, because I think you've covered some of the heavy lifting that I certainly didn't want to cover in my presentation. So as Tanya mentioned, we did work that was entirely unrelated to COVID-19, in that we studied the kind of outcomes and the experiences of SMMEs in the fish or industrial fisheries value chain, an issue which is very political and very contested and policy sensitive in the South African context. And in particular, we wanted to understand what's happened 15 years after the government essentially put in place rules that were going to allow for more inclusion in the sector, right? Now, what we've done in this presentation, and I'm working with a colleague, Stefano Ponte from Copenhagen Business School, is to see how those lessons from this research, which is very current. I mean, we were speaking to some of these SMMEs as early as March, in fact, how those lessons translate to the current COVID-19 scenario. And I think that's important because as much as there's quite a bit of international debate, I mean, Padilla, Petit, and Jenny and others are writing, I think we've got to grapple with the realities of our local economies, our local sectors, and design specific policies. And I think this is much of the message that Sumaya is putting out as well, to deal with the local challenges. The sad part, and maybe a good thing, it's kind of a confusing thing, is that some of the challenges that existed before COVID are still in place today, right? And so it kind of is a good thing, because it means that some of the thinking and gains that have already been achieved to this point to increase participation, etc., including the changes in the competition law, has already been done, and now it's about implementation, right? But I think this is where, as I think the Honourable Judge said this morning, this is where it's going to get interesting in terms of how these cases come out, etc. And so we tried to skew it to think about where does competition law fit into this wider context. Just briefly, and I won't say a lot about the context of this paper, except to say that it is on the main industrial fishery in South Africa, which is hake deep sea trawl. We are reflecting on a number of different themes, being BE, transformation, and competition. And we've done this through engagement with various stakeholders. My colleague or co-author Stefano was part of this work in 2005, and I've kind of joined him for the second leg of the work, right? And I know that, of course, there's also very interesting competition cases that have taken place in the sector. And so there's some nice connections in terms of the interface of competition with BEE. This is important for us because we also do think that the issues of Black economic empowerment, in particular in the South African context, and I think more broadly in other countries, Zimbabwe talks about indigenization, Malawi talks about including indigenous Malawans or Black Malawans more in business ownership, etc. These themes apply across the continent. We're using a case study of a South African sector here to illustrate them. Just very briefly on the sector, there was a huge policy program in around about 2005 or so, which had as its objective to reform the way in which rights for fishing were allocated. So it's a highly regulated sector. And in so doing, it tried to allocate a lot more of the fishing rights to smaller entrant companies, Black-owned businesses, etc., right, at the fishing level. And this is quite evident in this chart. So we did this big policy program around that time. You see a jump in the share of the what we call the medium and small sized firms in the sector. But really, and you actually see a dent in terms of the share held by the major firms in the sector. Right? So regulation did its job, policy did its job. It opened the door for these entrants, right? But we argue in the paper that we didn't follow through in the ways that we should have. And I'll get to that in the slide that comes up now. I think that we reveal in the paper the very important role that institutional weaknesses, and not only the state capture era in the South African context, but institutional weaknesses in terms of monitoring policy interventions. And I think this applies even in the competition law space. The ability to monitor the outcomes of interventions is absolutely critical. And what we find in the sector is that whilst we set the rules, we changed the game, we included the small guys, for 15 years since then, no one was watching. There was no socioeconomic impact studies. There was no studies to see how the included firms were faring in the sector, what sorts of terms they were getting from the larger players in the industry, etc. And so when we look back, we found that really not much has changed, quite disappointingly. Although at least these guys are still walking around with a paper that says, I have a certain entitlement to an allocation of fishing rights, right? Which I think on its own is significant. I have two more slides, and I'll touch on what we've tried to crystallize as the kind of broader context relevant principle points, right? That are applicable for economic recovery generally. The first thing is that this is a classic sector in which you're gonna have this tension between, and this is kind of linking with Sumaya's presentation, between consolidation and scale, which is a big argument that firms will advance in the current environment, right? We need to maintain scale. You cannot cut production if you want us to recover and become globally competitive again. Whereas this imperative, on the other hand, to drive rivalry and participation. And we argue in this research, but also in wider CRED research, that these things are not necessarily different, right? You can, and I think Sumaya is saying the same thing, right? You can achieve competitive outcomes, or outcomes that mirror competition, even if you're operating in an oligopoly context, etc. And that requires the interface of industrial policy and other different disciplines and constraints and conditionalities on the behavior of large firms in particular, right? So you cannot have concentration and still not watch what's happening in markets. And I think this is where the competition authorities can play a critical role. I think that there's going to be a lot of pressure and arguments for greater industry coordination. And we saw this in the fishing sector in particular, where there's very strong centralized lobbying for different outcomes, etc. in the sector. And of course, it naturally dampens competition. So that's an obvious point to make. But I think what was missing, we saw in this sector, and I think it's an important lesson, is that even under conditions of coordination, which is not necessarily a bad thing, and I think there's good research that shows that it can achieve pro-developmental outcomes. If that is not monitored, sufficiently disciplined, checked, evaluated constantly by the state and other actors in the sector, then you will tend towards outcomes that start to mirror a kind of hardcore cartel outcomes, where firms simply abuse their ability to coordinate rather than achieving or delivering on the developmental outcomes that had been promised. I think another important point here is that the issue of barriers to entry, whether we're talking about before or after COVID, is still entirely prevalent. The SMME firms are still talking about the same issues around access to finance, access to markets, being rejected from participating in mainstream value chains, etc. Now, this is an old issue. It's 20 years old in South Africa. And so we shouldn't shift focus because of the pandemic from trying to address these issues, both structural and behavioral. I'm not sure how much time I have, Tanya. I should have about 3 minutes, it says here. Okay. I think that there's a real challenge that we have to confront that relates to regulatory capacity. So I think there's a very clear acknowledgement in the South African context, but I think throughout the region, based on our kind of broader value chains research at CRED, that there is significant institutional weakness. I think in South Africa, obviously, this has now taken the form, if you're talking about newspaper headlines, of state capture, right? But I don't think it's helpful to stop there in terms of analyzing what the state can and cannot do. I think we advocate that in a rules-based system, like it or not, in the South African context, for instance, you do have pockets of excellence, including, I think, the competition authorities and agencies that can drive pro-developmental inclusive agendas, right? Whilst you rebuild as an imperative state capacity in other areas. And so I think that it's one of those where we don't give up on the issue, but recognize where there is capability, et cetera, that can be leveraged to continue to drive an inclusion agenda whilst rebuilding the economy, right? So if you take nothing else from my presentation today, is that the issues of inclusion, participation, and we're not talking about micro here, we're talking about medium-sized firms that can actually contest in markets and be effective rivals, right? Take on your larger firms. That agenda shouldn't fall away. And if it does, I think we'll be having some very disappointing and sad conversations in 10, 15 years' time again about how you still have a highly concentrated and uninclusive economy. So the time is now, I think, to change some of these outcomes. Lastly, I just want to comment that I think Black economic empowerment as a policy imperative in South Africa has achieved a lot in terms of certainly putting the issue of inclusion as a central feature in the debates, right, in the country. And I think arguably it had to take the form that it did in terms of policy formulation. That being said, it cannot do the heavy lifting by itself. And I think that's what our paper shows. So for instance, in the sector, you had a lot of large mergers being approved in the sector because I think the competition law agencies couldn't reach another decision on the basis of the facts before them, right? Now, you can blame them, you cannot, but the challenge there is that you still now have a problem where you've seen significant consolidation in the sector, which now is going to evidence itself, we would argue, in terms of a lack of dynamism in that sector, right? And so all the other policy tools, including competition law, remain incredibly important, and including the way we enforce on mergers, right? So, and I can always come back to this in the question session. Tanya, just to conclude here, I think that COVID-19 and kind of transformation, what we call transformation 2.0, presents an opportunity as well, because it asked us to ask some hard questions about whether our policy frameworks actually work, as Judge President said this morning, as Judge Dennis Davis said this morning, for 60 million people in the South African context, right? Have we done the right things in terms of inclusion and participation? And I think the time is now to test these things, right? And COVID-19 creates at least the psychological moment in the nation, if you will, and in our economies to test out new approaches, right? And I think the competition authorities in particular have been quite bold on this in the past, on public interest and other issues. And I think this is the perfect opportunity to pursue these agendas further. But the issue of inclusion will fall through the cracks if there isn't adequate coordination between, and this is exactly what this case study reveals, if there isn't adequate coordination between the sector-related policy, in this case was the marine rights, the MRLA, I now forget the acronym, with industrial policy strategies to build domestic new capacity with competition law enforcement, right? There was no coordination. And so in many ways, your medium-sized firms fell through the cracks. And my last point really is that power asymmetries and inequality will be reinforced in the rules-based system that we've chosen as a society in 1994, right? If you have weakened state capacity and a lack of coordination. But I want to argue, and we argue in the paper, that there is pockets of strong state capacity. And so there's an opportunity there perhaps to intervene on some of these threads, which I think we've been discussing for years now. Tanya, I'll stop there. Thank you very much.
Thanks very much for that, Thando. That was fascinating and gives us a lot to think about. What strikes me from all the presentations is that even before COVID, we had a range of challenges. And the question then was, is our competition policy and competition law framework fit for purpose? While we, start my video. While we have seen the competition authorities being highly effective in a number of instances. So for example, cartels have been uncovered and prosecuted, anti-competitive mergers have been prohibited. We still face an economy that really requires structural transformation. Concentration seems to have increased over the last 20 years. We've struggled to diversify our economy, and barriers to entry remain high. The prescriptions, the common ideas in the prescriptions from the three speakers, and the prescriptions really point strongly to the need to have coordinated industrial policy, where competition policy should interact more effectively with industrial strategy and regulators, and should play a more proactive role. But we also need to look at a range of tools outside the competition area and perhaps outside of industrial policy narrowly defined. So for example, if we look at the quotas in fishing, those licenses and quotas need to be brought on board. But while we're doing this, the challenges that we're already facing are being exacerbated by COVID, and there's a danger that gains made may be eroded, that we could face an increase in competition, and that our efforts to make our economy more inclusive could be undermined. In looking at how we address that, participants have emphasized we need to look at the ability of the state to ensure that we have the coordination across different departments and across different role players, that the analysis on competition policy and from the competition authorities needs to look at the impact of global value chains, and that we also need to look at the changing international trading environments. So we know that there's a move towards nationalism, a decline in trade. Lastly, what had been strongly suggested is that we address institutional weaknesses. So for example, we have more monitoring and evaluation. That monitoring needs to constantly take place, and in fact, research needs to be done by the state. The key questions that have been addressed are how we look at the trade-offs involved in protecting the domestic industry from competition, and how a more competitive approach can contribute to other public policy objectives, such as reducing inequality and promoting innovation. I had a range of questions that I'd been quite keen to ask, but I see that I'm trying to organize my screens. There are a lot of questions that are arising from the floor, and I just want to ask panelists, the first question to any of you is, how do the panelists propose, what do panelists propose be changed in merger control to promote economic recovery? And the second question that I'm going to link to that is that working with large firms, even with conditionalities, it may be convenient in the short run recovery process, but it may risk long-term entrenchment and dependency. And should we rather be focusing on scaling medium-sized firms and addressing the barriers to expansion? So I'm going to hand to any of the panelists. You can just indicate who wants to speak and pick up your answers, please.
Sure, maybe I can start here, Tanya. I mean, I think I fully agree with the second comment, which is that, you know, and you see this currently with the sector master plan process that's underway, even where the government is having to get into arrangements largely with the incumbent large firms in different sectors, with a view to sustaining jobs and hopefully turning this economy around in the long term, which is important, right? The short-term objectives of retaining jobs, etc., are especially important. But that does absolutely nothing, as the commentators said, or suggests, I guess, it does absolutely nothing for building long-term capabilities and dynamism, right? And so this idea, as the question speaks about, of finding ways to, in particular, scale your medium-sized participants in different sectors is absolutely critical. If we can crack that, I think we're on a good path. Someone said on a panel the other day that the problem in maybe the South African context is that at least from a policy point of view, we've gone and lumped SMMEs together as one big grouping of disadvantaged firms, whereas actually maybe we need to start thinking at the level, well, what does it take to get your medium-sized participants in different value chains to tick, right? And within that picture, what can competition law agencies do to open up, in particular to do with strategic barriers, right? Because that's precisely what competition law can do very well, is deal with conduct, open up the thing. And then your industrial policies ideally follow through by bringing the support measures that then strengthen the firms once the door is open, right, and enable them to participate. Busting a cartel alone, as Sumaya said, doesn't necessarily mean that you'll have competition. I think on merger control, just to say a couple of things on this, at least just initial thoughts, is that there's quite a bit we can speak about in terms of the failing firm issues and that, and I think the competition authorities have been very good in their history of dealing with these issues on a case-by-case basis anyway. So I don't think there's a problem there, and the appropriate tests will be applied, etc., right? And fairness and all of this. But I do think there's some blind sides that we might think about here, or certainly some blind spots that we might think about. I think that the issue of ensuring pass-through is especially important. I think the issue of how we treat and verify and ask firms to substantiate efficiencies that are claimed of different is going to be especially important now. Because you're allowing consolidation, but if the efficiencies don't arise over the medium to long term, you've cost that sector in terms of dynamism, right? And the damage will be much longer over the long term. So the way we treat those issues in merger control is going to be especially important. And then just lastly, which is maybe a kind of fresh thought, I suppose, that maybe needs some thinking, is that I think monitoring and evaluation of remedies, of conditionalities, of outcomes of mergers, impact assessment, etc., is going to be more important than ever before. I think it's often underplayed, and you have 2 or 3 people in a division that monitors the outcomes of all the merger transactions in any given jurisdiction or whatever, whereas actually testing and learning from whether the decisions we make have bad or good outcomes in the long term or over time is especially important if you are to crack open this issue of opening the South African economy. I'll stop there.
I'm happy to jump in. Thanks for the questions. I think they're all from James. Hello, James, how are you? I think there's a third one as well around merger control as reactive. I mean, I certainly don't have complete answers, and Tanda's done a good job. But I will say though, I think there are some suggestions out there on how merger policy or merger control can think about, changing the standard modus operandi. I mean, one suggestion is, as a result of COVID, there's lots and lots of news and discussions around industry restructuring, and there is a sense in which perhaps competition authorities can see restructuring coming and can coordinate with bailout programs. I mean, Padilla and in that way, take a sort of more proactive and perhaps more creative approach to merger control in sectors that are inevitably going to go through a restructuring process, rather than wait for mergers to be filed and look at them on a case-by-case basis, as is currently the way it works. Padilla and Petit, they talk about, you can even go so far as looking for the firms in a sector that may be really struggling, but are actually, have longer run potential to be more competitive because, for example, they're operating closer to the technology frontier. I don't know how you go about identifying those things, but maybe there are ways. And then you coordinate with bailout programs to help those firms and not the old dinosaurs that are not operating close to the technological frontier and are carrying a lot of inefficiencies that have been exposed by COVID. And this is, I guess, the cleansing option, or the cleansing idea that they propose in their paper. The other suggestion, or the other risk, I suppose, identified is, in a time of massively depressed demand, and small firms likely to be showing a lot more weakness than perhaps bigger firms, this killer acquisitions idea in digital becomes an even bigger risk, and spread across more industries. And is there a way? I mean, I guess current law makes it difficult, but is there a way that competition authorities can be more vigilant around potential killer acquisitions, which may kill off dynamic firms that may in future contribute more in terms of competitive constraints on incumbents. But it's a difficult issue because the law is set up, the merger control law is set up to be passive and reactive, as James has pointed out.
Right. Sumaya, I don't know if
can I come in there as far as the large firms and conditionalities and working with medium-sized firms is concerned? I think we also need to think about the reality of what actually is. And in the South African context, there are large firms at the upstream level, for instance, AMSA, Sasol, etc. And so we have to think about how we deal with those firms and how we actually approach those firms, even in times when resource prices are going down, etc., for the benefit of the downstream. So the reality of the situation is that we do have to deal with them in some way, but when we do deal with them, that we think about these conditionalities. But at the same time, not just looking at the upstream firms, thinking about industrial policy at the downstream as well. In other words, for machinery and equipment firms, for plastic firms, etc., what are the kinds of policies that we can put in place in terms of technology, in terms of clustering, etc. So I would say that the reality is that we will sort of always have to deal with the upstream firms. It's kind of how we translate that support to them into something positive for structural transformation downstream. So for instance, with Sasol, we saw polymer pricing that was actually quite favorable, not favorable, but actually helped downstream industries until 2002, when Sasol started pricing polymers at import parity level. So I think a kind of balance needs to be struck there.
So we got an interesting question which relates strongly to how we deal with the larger firms and the conditionalities. And Beverly asks, is our South African government willing and able, given the current political settlements, even within the governing party itself, to focus on building capacity and enforcing the reciprocal control mechanisms required? If competition law takes a back seat for capacity building, what happens to firms that are already dominant? Won't they abuse their power and reverse the capacity building efforts? I don't know who would like to comment on that.
Yeah, I'll have a go. I mean, that's similar to James's question on conditionalities. I mean, I completely agree. My personal view is that there are big risks here. Bigger firms are already on a relative basis in the pound seats compared to smaller firms, purely because they should, in principle, I suppose, be better equipped or better able to survive a potentially lengthy downturn in demand. And as smaller firms exit and import competition tapers off, these firms are already able to operate in a less competitive environment with fewer constraints. And so I agree with the sentiment behind the question. I see big risks. And I don't think that competition enforcement around these issues should take a back seat. That's my personal view. But our paper is all about saying, well, there's a lot of different views on this. And certainly some prominent voices in Europe don't really see that as a big risk necessarily.
So can I come in here as well? I think that competition law should not be taking a back seat necessarily, but and I'm going to bring this back to AMSA and Sasol. What we saw in the cases of AMSA and Sasol and the excessive pricing is that these cases went on they're quite litigious. They went on for quite a long time. And that the outcomes were not necessarily, were not good for downstream industries. In other words, competition law is a tool, but in addition to using the tool which is already there, we have to think about other tools as well at the same time in order to get where we need to get. The evidence is there. South Africa has not transformed. We have been trying to use competition law. We have used competition law. We have sort of taken a back seat on other kinds of mechanisms, and the results have actually been quite poor. And so I don't think it's about competition law taking a back seat so much as thinking about how competition law and competition policy more generally can work together with industrial policy to get where we need to get.
Tanjo, I don't know if you want to react to this, or if we can move to the next
Yeah.
question.
Yeah, I mean, I'll just say, Tanya, a quick point here, which is that I think the sentiment of the question is absolutely right, that there's a broad kind of state capacity issue, right? And this doesn't just apply to South Africa. But I also think that economies, are built a sector and intervention at a time as well, right? And I think that there are pockets in which you can make important interventions that will have long-term impacts on inclusion, on growth, et cetera, on dynamism. And I think you usually can look only even at the competition authorities' interventions on things like data prices, which have very important implications for dynamism and the businesses that can start to leverage the fact that data costs are cheaper in our economy now, Those are very important interventions, the interventions in the grocery market inquiry, right? And so you're not asking the competition authorities to do anything different from what they've done before, right? Necessarily, even within an environment where there's been a decimation of state capacity in so many other sectors, right? The fact is that there are capabilities here. There's a working framework. There's tremendous skills and technical ability within the authorities. And there's no reason, as I think Judge Davis was suggesting this morning, that the competition authorities shouldn't, in the next era, focus in particular on issues of inclusion as well. So I don't think it's either or. I think it's somewhere in between.
If I could just 2 cents on the mobile side to pick up on Tando's point. I mean, it's interesting what happened in the data services market inquiry with those settlements and the retail price reductions that Vodacom and MTN put through. I agree. Cheaper data, cheaper mobile data, is good for lots of downstream activities. But there is a question around the approach there. In the long term, I guess what you might want is effective rivalry to MTN and Vodacom from networks or operators that are currently smaller. And one route for them to get there is to be able to charge lower prices. I mean, that's their primary competitive advantage, given that they have smaller networks, lower quality, and so on, and various other disadvantages. And so there is a question that was raised at the time when the settlements went through. What happens to that competitive advantage, and does that intervention promote, long-run dynamic competition sort of objectives? Or is it another example of focusing on sort of short-run static gains at the expense of that longer-run dynamic process? That's just a question.
Thanks very much. We're moving towards the end. We've gone 5 minutes over time. I just wanted to ask panelists one more question. There's been an emphasis on promoting competition and ensuring that competition law is strictly applied and that we get developmental outcomes. There's been an emphasis on improving coordination within the state. But what had been raised, albeit briefly, is the need for some cooperation between industry players to help promote the recovery. And I'd be curious from you on what you see as the dangers, potential dangers of competition. And a further question is, can block exemptions on impacted areas aid in recovery? Phil, specifically, it's asked to you, in your opinion, is a 2-year sunset period on the block exemption sufficient?
I'm going to toss that question to Pamela because I don't actually think I can answer it. But Pamela might have some views on that.
Okay, Pamela, please feel free to join.
Okay, good afternoon, everyone. I think on the question around block exemptions and whether or not a 2-year sunset period is sufficient, I don't think there can be one answer for every industry. It really depends on the industry context as well as the nature of the conduct that was allowed. I mean, if you really strip all these arguments down, what they're saying is you need to consider what it takes for firms to be able to succeed. So you need to understand the process of production and the interactions that are required. So that may mean that firms need to cooperate for 2 months, for 3 months, for a year. It really depends. So if it's cooperating in order to export for a 3-month period, then you can shut that down in a relatively shorter period. But if you are saying firms are coming together to invest in R&D in order to improve, their technological capability so that in the long term they can be internationally competitive, that might take a few years to work out. And caution that needs to be exercised there is also, once you allow firms to cooperate for 2-3 years, they start to understand how they each operate. And once the exemption, is no longer in place, that understanding doesn't suddenly go away. So then when you're thinking about the conditionalities that you put in place, you really need to consider, what harm will happen in the long run should we allow this conduct. And if there is long-term harm that's going to happen, such as, for instance, creating some sort of market power that can be used to extract high prices from downstream industries, then one of the conditionalities that should be placed should be longer term to ensure that that doesn't happen. I'll leave it there for now.
Any other panelists want to speak on the issue of cooperation?
Yeah. Tanya, I'll just make 2 points here. I think I agree with Pam. The risk is significant, right? But there will always be somewhere in there some very good rationales. And so you can't rule out that some firms may come with good cases for coordination, right? And I think we accept this now. I think what's nice is that also the international kind of jurisdictions and literature and scholarship on competition law is accepting that the window is open to allow these kind of more creative forms of coordination, or actually what is really state intervention in the dynamics of markets, right? Which is nice. So then we're not doing the same things we do with public interest, where we're standing out from the rest of the world. But 2 points on this issue. I think that, first of all, there is a very good literature, in particular on the longer term outcomes of coordination in markets such as pharmaceuticals, et cetera, where you often have specific project-specific coordination for to maybe develop a drug or to do some kind of R&D activity together, joint ventures, etc. And there is evidence that suggests that over the long term, as Pam is suggesting, that familiarity that firms develop over time does mean that even once those arrangements stop, that familiarity and this kind of close context between the firms allow them to coordinate more subtly in other areas as well. So we've got that risk to deal with. And so I think it puts a lot of pressure on our monitoring capacity and tracking of what happens after these arrangements are in place. The real question about who is watching, and I think you can think of various examples like the exemptions in South Africa's fuel sector, where it's not clear to me necessarily, or at least in the research that's been published by GRED, that those exemptions should have been rolled over as easily as they have been done for as long as they have been done, right? So we're not watching the outcomes of these types of block exemptions or whatever it might be. And that's the downside risk I think we need to be worried about.
Thanks. So Maya, I don't know if you want to, you're happy. So then we're now 10 minutes over the ending time. We had been given a free ride to go a few minutes over, but I don't want to push our luck. So just to thank each of the panelists for really thought-provoking and very useful input. Certainly as a person working on policy, you've given me much food for thought, and that's greatly appreciated. And to thank participants for sharing questions and comments. I'm sorry we couldn't get to all of them, but I'm sure that you'll be able to pick issues up through the rest of the conference as well. So thank you to everybody, and we wish all future panelists and the rest of the conference a very fruitful discussion.
Thank you very much, Tanya. And I just want to emphasize thank you to all our panelists for your contributions. So I heard Judge Dennis Davis say that we've done okay in the last 2 years. And I heard our panelists as well set us some challenges for the future and opportunities for how we can do better. Let me close off with Tando's words. He said, this is the perfect opportunity for us to pursue these agendas further. And taking our work further is precisely what we hope to get out of these academic sessions. And I think you'll agree with me that that is what has happened just now. So thank you all for taking us a little bit further. And thanks, Tanya, to you for moderating that discussion so well. So now let's break for lunch, please, and come back refreshed for our next academic session at 1:30. Thank you.